The legislature, in their infinite wisdom, expanded the statute of limitations for claims under the Fair Employment and Housing Act. And for those of you that are familiar with that, that's pretty much any employee who sues you for discrimination, harassment, pretty much anything, they're going to sue you under the FEHA. The existing law for 50 years has been you have to file a claim with the DFEH within a year after the events occurred. And usually that means if the employee is terminated, you know the statute runs a year from the time that they were terminated. You had some comfort in that. And then the employee has, once the DFEH gets the claim and they close it, the employee has another year in which to file a lawsuit. So if you're an employer and you go, okay, I'm firing this employee on November 30th, you know that on December 1st, 2 years from now, you're probably home free. Under AB 9, which was passed this year, it extends the deadline to file a DFEH claim to 3 years. So that's triple what it was before. It's 6 times what the federal limit is. So for an EEOC claim, it's only 6 months. And what that means is, this bill actually it's been presented several times over the last few years. Governor Brown has vetoed it, I think a couple of times. His feeling was people need to file claims in a timely manner while memories are fresh and while the evidence is still around. The new statute, though, from departure to lawsuit, can now be 4 years. That's a scary prospect for any employer. It's effective January 1st of next year. It does not revive claims that have already expired. That's the only good news that I can give you on this. And what, in terms of protecting yourself, all I can do, and I think sure Kathy and I say this over and over again to everybody we talk to, document, document, document. And what it means is if you have an employee, you need to document who's going to be terminated, document the reasons why they're being terminated, and you need to keep that documentation for at least 4 years, and I would suggest probably even 5 years, just to be safe. And notice that statute of limitations, that time period for keeping those documents is longer than some of the other statutory requirements for keeping documents. Another change, lactation accommodation. Now, existing law, I think people probably know you have to give a reasonable break and you have to give them a reasonable location other than a bathroom to express milk. Section 142, which was passed, or Senate Bill 142, which was passed this year, was modeled after a San Francisco ordinance. And it was previously vetoed by Governor Brown as being way too onerous for employers. Governor Newsom didn't quite see it that way. There's a list of all the requirements that the room must meet in order to satisfy the statute now, and they're listed on there. I'm not going to read them all. In addition to the requirements for the room itself, there has to be access to a refrigerator and running water within close proximity of the employee's workspace. There are some interesting issues for ag employers. People in employers in multi-tenant buildings, they can combine together and have one space. But it has to, the primary lactation has to take precedence over other uses of the room if you're going to do it that way. Equally important, all employers must now have a lactation policy, and they must distribute it to all of their employees. You put it in your handbook, and you distribute it to your employees. The violations for this are labor code violations that are enforced by the DLSE. So this is the people who enforce the wage and hour laws. And it's a $100 penalty per occurrence, and it's anybody who's ever had a wage claim knows those penalties can start to pyramid pretty quickly. So everybody should make sure that they have a policy, that it's distributed to people, and that they've taken account for the new requirements. If you're under 50 employees, you can apply for a hardship exemption for this, but you have to show undue hardship based on difficulty or expense, and that you made a reasonable effort to provide a space other than a bathroom stall. Next one, expanding to hairstyles, the Crown Act. And the Crown comes from creating a respectful and open workplace for natural hair. This is my natural hair, everybody. The legislature stated that the purpose of this statute was designed to prevent Eurocentric professional norms by prohibiting workplace dress code and grooming policies that prohibit natural hair, including afros, braids, twists, and locks. And it bans basically bans discrimination based on protected characteristic, and it makes hairstyles part of a protected characteristic. It also bans discrimination based on someone being perceived as having a protected characteristic. So if you are perceived as having, if you have a hairstyle that indicates you might be in a protected class, then you're perceived that way and you're discriminated against because of that, that creates a problem. It amends the definition of race to include traits historically associated with race, including not limited to hair texture and protective hairstyles. Sexual harassment training. Everybody probably knows, well, if you have more than 50 employees, you probably know that you're required to train your supervisors 2 hours of training every couple of years. Last year, that requirement was expanded to any employer with more than 5 employees. And it also added a requirement that all employees have to get 1 hour of sexual harassment training every 2 years. Now that obviously created this was passed at the end of last year. It gave people 1 year to get all this training done. And for small employers, because this applies to anybody over 5 employees, it created a problem. So the legislature, this is one bone that they threw to small employers, is they basically extended that deadline to January 1st of 2021 instead of 2020. So you have another year, so you can now wait until next November, and then you either panic and do it, or you come to the employment law date and we tell you they've extended it again. I don't think that that's likely, to be honest with you, so if you're a small employer, I would suggest that you start thinking about this now. It applies to seasonal and temporary workers after a certain amount of time. And new employees must be trained within 6 months. Now, it's unclear if you hire somebody between now and January 1st of 2021, whether you have to train them within 6 months or not until after the deadline for doing it, which is January of 2021. So I guess caution is the better. If you're the rat and you're looking to minimize risk, I would do it after 6 months. There is a new trend in ADA claims now, and it's website ADA claims. So if you have a business that sells either a product or a service via a website, it has to be able to accommodate disabled people in a way so that they can use your website. And if it doesn't, you could be in trouble. There was a case, a Ninth Circuit case at the beginning of this year that basically said the ADA covers any website with a nexus to a physical place of accommodation. And you could be, now the problem is, there's really no regulatory standard as to what you need to do in order to have an accessible website. There is an organization, the Web Content Accessibility Guidelines, that a lot of the courts use those, but it's not a regulatory framework. So there's no one really even knows for sure what it is you have to do to make the website accessible. But if you don't, you could be sued. There's another case that came out at the California Supreme Court in August of this year that said that if you're trying to use a website that relates to public accommodations and you can't, that could be a violation also of the Unruh Act, which prohibits discrimination in public accommodations in California. The other issue that's come up recently, and it's primarily on the East Coast now, is gift cards. If the gift cards can't be read in Braille, there are now a bunch of lawsuits that have been filed. No one knows how that's going to resolve. There's been no court decisions on it, but this is what people are looking at these days.